What is an executor? An executor is usually the person nominated in someone's last will and testament as the person to be in charge of administering the estate of a deceased person. And you may have seen in wills, I appoint so-and-so to serve as my executor. Sometimes people use personal representative in their will when they nominate. So instead of saying I appoint so-and-so to serve as my executor, they say I appoint so-and-so to serve as my personal representative. So these people, these titles have really the same role. The difference is that an executor may be nominated in a last will and testament. A personal representative usually is used when there is no estate plan in place and someone has to file a probate, and the court appoints the personal representative to handle the affairs of the deceased, to do whatever is needed. It's worth mentioning that one does not automatically become the executor or the personal representative just because they are nominated in the last will and testament of the deceased person. There is a legal process, a probate, through which the court officially has to appoint that person in that role through a hearing, and there is a petition that has to be filed. That executor or that personal representative will have priority to serve if they are interested, but they could always resign. So just because you nominate someone as an executor or as a personal representative, it does not mean that those people will end up serving, and that's why it's a good idea to always have an alternate executor if the first person you nominated is unable or unwilling to serve. If one does not have an estate plan in place, who can serve as personal representative? Well, it depends. The law has a list of priorities, or who can apply first and who may be selected as the personal representative, but ideally have something in writing and tell the courts who is the person you trust to be in charge of handling your money and your assets and maybe your minor children. I have mentioned throughout my video probate, the courts, because if you do only have a last will and testament or no estate plan at all, a probate will likely have to be filed for the estate of someone who passed and who owned real property, such as a home, land, mineral interest, or for someone who passed and does not have beneficiaries designated on their financial assets, such as life insurance or retirement, stocks, and such. So get an estate plan in place. It is much cheaper than having to go through probate and will save your family lots of money and hassle down the road. Thank you for watching.